Yes.
May it pleases your lordship. Lordship, I'd like to mention item 20, lordship, of today's list.
Yes.
Lordship, this may be taken up on 25th because a similar matter is pending because Wajuddin, the petitioner's brother who is in detention, his case is pending on 25th. The date is fixed. So along with writ petition 3767,
Okay.
2025.
We are not attaching it, but we'll say it on 25th.
Yes, on 25th.
Item 20. Item 20 with 21. Both sides are represented on the prayer made by learned counsel for the petitioner. List the matter on 25/7/2025.
Deeply obliged.
May actually see Lordship, I beg to mention for listing of a IA along with the petition for correction of the order, my lord. Obliged.
May it please your lordship. Lordship, I am praying for a listing of repetitions.
Give it, there will be some adjustment this week.
May I please your lordship? I'd like to mention prayer for listing of a writ petition, which has not been listed since 2021.
Give it this week, it may not be listed, but give the mention note to the court master.
May I please your lordship? Lordship, I beg to mention item number 15.
15.
15. Lordship, I am praying for an adjournment for the day.
So as a representative of the prayer made by counsel for the petitioner list, it goes after 2 weeks. 2 weeks.
Please, Lordship. I would to mention IA for listing, Lordship, for the correction of orders.
Give it to the court master.
Yes, may I please, your lordship, it's the whereabouts of the mother of the petition is not known. Well, if it maybe come tomorrow. And then may I mention item number 1 and 3? It's item number 1 and 3. Both the matters are similar matters. The whereabouts of the petition were not known and the relatives were before your lordship. In both the matters, visitation rights were given. Visitation rights were given to meet the members, the detainee. Now we have exhausted that right. We have to, on the merits case, we have to approach the Honorable Supreme Court. So we are still in the process. If your lordship, it may come up in the first week of August.
No, but then there's no point keeping it pending.
No, my lords, because we are also planning to submit written arguments with respect to Article 22 and arrest of a DFN. Because that's something, my lords, that's a point that we have also raised in our habeas. Because while arresting, they still have to give us a written arguments, written grounds of arrest. A notice has to be served. Here,
If you want that, we can dispose of by an order passed today.
well, please hear us on that. Let us just submit an argument.
This is two extension of the provision of, he is not arrested for any crime under BNSS.
Yes.
So why grounds of arrest?
Because Article 22 is a longer right, my lords.
Whatever you want to make, you make your submissions, we'll deal with it.
Okay, so let come on.
How do you make it?
Within 2 days time, my lords. Because we are submitting written arguments also, we won't take much time.
You do it, but. Okay. In item 1, item 3 will be similar order, but say different, separate orders. Both sides are represented. Mr. D.K. Agarwal, counsel for the petitioner, submits that pursuant to orders passed by this court, the petitioner has been able to meet the detained person at the holding center. First of all, he submits that the detained persons would be pursuing their right before the Supreme Court of India. So however, it prays for an adjournment. Next paragraph. As the main purpose of this repetition has been served. Make it next Monday, based on 28/7/2025 in the orders column. Notwithstanding that notice of motion has not been issued.
You can submit written arguments, written arguments.
We do whatever you want. We are not saying, we are not giving you liberty for that. You want to file it, you do it. We are not giving
Hard
you-
copies may be served, Lordship. Hard copies of the writ petition, Lordship. We are getting only soft copies, Lordship,
This of the-
in these two writ petitions.
Explain in the meanwhile, the learned counsel for the petitioner shall provide a hard copy of the writ petition to to Mr. G. Sharma and his standing counsel for the FT matters.
Daily list item 2 for motion.
May I please, Lord? My lord. In this case, my lord, our specific plea was that, my lord, there was no case pending or decided against us. But we were picked up, my lord. My son and wife were picked up on 25th of May. Nowhere about was informed to us. Then, my lord, we approached this on court. On 27, my lordship, kindly see their instruction, my lord. Your lordship recorded, my lord. On 27/6/2025. They instructed that 2 cases were decided against us. And your lordship granted us visiting right and other formalities, my lord. On 28th, my lord, we went to Kukrazar. Then, my lord, they said, my lord, already police has taken back. They were not there. And police has taken back because there is no case. And now they have been released, my lord. So let them file, my lord, affidavit, my lord, in this case, my lord. Because wrong instruction was given to this on court.
Okay. Mr. Sharma, you ask your authorities to give file an affidavit. Who will be the authority to give you affidavit? Who will be filing the affidavit?
Lordship. Concern SP, Lordship.
Superintendent of Police.
Yes, Lordship.
Okay. Mr. R. Ali, and, all sides are duly represented. I suppose. Mr. R. Ali and Command and Counsel for the petitioner has submitted that on 27/6/2025, relying on the instructions produced by the learned standing counsel for the FT matters. This court had recorded that the jurisdictional foreigners tribunal had passed an opinion dated 25/2/2019 in FT case number 200/2014. As well as and furthermore, by another opinion dated 27/4/2020 passed by the jurisdictional foreigners tribunal in FT case number 1782/2011. The petitioner, next para, sorry, within bracket. No, not between, the petitioner, comma, Habibar, Habibar Hussain, within bracket, Habibur, Habibur, Habibur Hussain, as per instruction, bracket close, declared to be a foreigner. Next paragraph. Is submitted that pursuant to the order dated 27/6/2025, the petitioner had approached the holding area, 7th Assam Police Battalion, Saraikula, Kokrajhar. But he was informed that there was no case against the petitioner and therefore, no case against the detained person, namely Habibar, Habibar Hussain, and therefore he was released. Next para, in that view of the matter.
Habiba as well as her mother also, Fatima, my lord, 2 persons, my lord.
Okay, and Fatima Begum. 2 persons, huh? Detained persons are 2. So next para. If you, court is inclined to direct the superintendent of police within bracket border, bracket coast, Golaghat, to file an affidavit explain the circumstances under which instructions were provided to the Rana Standing Council for the FT matters, which is recorded in the order dated 27/6/2025. Next para, the affidavit shall be filed within within 1/8/2025. Next para, list on 1/8/25. Next para, the Rana Standing Council for the FT matters shall send a downloaded copy of this order to the respondent for, which would constitute a notice to the said respondent. Next, list on 4/8/2025.
Lordship, copies may be served.
Just to be mild punished.
2 copies, Lordship.
Before we exit, said that the counsel for the petitioner shall provide 2 copies of the petition to the understanding counsel for the FT matters.
Okay.
Item 4.
Yes.
Similar matter relates to the habeas corpus petition we have filed here. My son is missing from 14th of January 2025. I've lodged a FIR at the Thelamra PS matter. They have given me some indication that your son has been found in Delhi in some Prashant Kunj matter. I went there, but I did not find there. That is a different person matter. Then again, I reported the matter to the Thelamra PS. But till now, nothing has been done with it.
Where is the FIR you have lodged?
My FIR is at page minute. Page 23 kindly, Paris minute. I've approached the superintendent of police also on 5/2, page 24, madam.
In all your letters, you are referring to the earlier complaint by your wife. Where
Ye-
is that?
Wife is no more, madam.
No, where is the complaint? You're referring to complaint. Where is that complaint? Do you have a copy of that?
It is not annexed here, madam.
No, you must have a copy of that.
Yes, I can procure it.
You have a copy with
I
you?
don't have, I have to. দিল্লি গৈছিলো আমি, নাপালো তাক। খেলামরা সে কৈছিলে দিল্লীত আছে বুলি।
What does your son do?
মানে he is an engineer. দিল্লীত মই গৈছিলো, সিয়ে ক'লে তাতে আছে বুলি। কাম কৰিছিলো দেখি। কৰিছিলে, ঘৰৰ পৰা ঠেলামৰাৰ পৰা নাইকিয়া হৈ গ'ল।
নোটিশ ফার্স্ট দিন নোটিশ হয়ে যাবে।
You produced that copy of complaint, earlier complaint of your wife,
GR case number 7210,
case number
72, GR case 7210.
72 of 2010.
Yes, I will bring that. But in the meantime, my friend can take instruction of the progress of the GD entry made from Telamara OC. Madam.
Noted. Annexure 5, my lord, read by OC of Thenawara, Ominous Das. Annexure 5, lords,
Answer
Annexure 5, my lord, page 30.
page number
30.
30.
It is he already informed him that relevant portion may read lordship. Page 30.
As per the instruction of OC, we went to the Delhi, Lakshmi Nagar.
Self SI Rajkumar, Lakshman Nagar,
Yes.
New Delhi, visited the site address to given OC Thelamara PS on Iman. Owner of the residence stated that no person, namely Vivek Das, is staying into the private residence. Accordingly, SI Rajkumar informed to OC Thelamara PS over phone. Thereafter, OC Thelamara PS gives another address over WhatsApp number and directed to proceed the new address, namely
Shri
Sai
Anand,
Anand,
Sector
Sector
60,
60,
Noida.
Noida. And at 28/5/25, visited the site address directed by OC Thelamara PS and talked the security officer Ram Kushal, who stated one employee, namely Vivek
Pantry.
Pantry of
Nepal
Nepal
original.
original, but photo of my son are not matched with him. Moreover, now he is
On leave.
on leave. Then suggest the security officer to communicate with me and employee after joining on duty. Thereafter, the security officer informed to OC Thelamara PS over phone in detail regarding my present and photo of my son and not match with the employee of
Shri
site
Anand.
and namely Vivek Pantry. On Iman 2 p.m., employee of Vivek Pantry after joining the duty communicate with
MW on video.
video calling on so and so number. After seeing appearance of the identified him is Vivek Pantry of Nepali community, then identify he is not my son. According to so and so appearance into Thelamara, PS reported to the duty officer LC details Iman. This is for your confusion. It is by the ominous das Thelamara PS.
Where from OC is getting this information, but we do not. And accordingly, we proceeded to Delhi twice.
This phone of your son is currently located at latitude 79.0 north and east longitude 20.6. He's in a building which in the Google is numbered as 41553001940877. That means your son is not communicating with you. Or he has given his phone to somebody else. This is your location of your son.
আছে, খবর আছে। এই নয়টাত কাম কৰিছিল তো।
ধরা নাই বেরিয়ে আসছে।
স্যার,
His phone is switched off and switched on and is working. If the telephone number you have given is correct,
Yes.
in your FIR that telephone number if you have given is correct, then that is the location.
That's why I take the help of the honorable court that read the proceed.
what does it do? He's on my road.
No, you see, we are anxious about because of another thing. You say in your complaint, you say that you have a dispute with this family, and then you use a word that they are being harassing you for pecuniary gain. That means there is some sort of private civil dispute between you and your neighbor,
That suit is going on.
and then you are
Suit is
using.
going on. Shyamala Acharya.
And then your son is suddenly not there, and you take the advantage, you lodge an FIR against your neighbor, saying that he is involved in the kidnapping.
That we thought that matter his handiwork is there.
No, but it's okay. But you see, this police went there. In the two locations where they went, they get another person,
Yes, not this man.
not this man.
Police
So-
did not go. He sent us. I went.
What will be what? This is the current location being shown. Not very difficult to find out people nowadays.
Yes, I have taken your. I deeply appreciate your lordship effort, but immediately you got this. That is the artificial intelligence handiwork of.
No, it's not artificial intelligence. It is real-time intelligence. To get a tower, I forgot the number. It may be wrong. Simultaneously, 9 or 11 actions take place to locate somebody in the mobile. When I am calling, when A is calling B, by the time the numbers are dialed, about 11 functions take place immediately. So that call of A goes to B. He's located somewhere, he gets the nearest tower and then he gets the call. I forgot, maybe 9 or 11, I forgot. I read it long back. So we do the reverse and then this comes out. So this mobile is available, and if your son is not contacting you, maybe he doesn't want to.
Maybe, mother want to be, keep in touch with me also. Might be, either way. That's why when I'm worried for that. If I could know that he is still.
Mr. Sharma,
alive.
can we ask the ask you to get instructions as to whether this mobile location was tracked by the police or not? They have a better device. Every police station is equipped with a better device to find out this mobile locations.
Thelamara PS.
Thelamara PS.
Thelamara PS. So they
We'll
produce.
take it up next week. In the meanwhile, we'll also produce the copy of
Lordship.
selection. You try to
Real
get it.
case, I'll do.
Okay. Heard Mr. S.C. Viswas, and counsel for the petitioner. Next, also, no, same, also heard Mr. P. Sharma, and standing additional senior government advocate appearing for the respondent numbers 1 to 6. Next, the case of the petitioner is that since 14/1/2025, his son, namely
Vivek Das.
Vivek, how do you spell it? Bibek, Vivek Das. With mobile number 84718-22154, is missing from village Thelamara, Thelamara, in the district of Sonipur, Assam. So in this regard, an FIR was filed on 3/2/2025 before the officer in charge of Thelamara police station, but the petitioner's son could not be located. Next para. It may be. Although the court does not take responsibility of the data which is available in the internet, but on a search made in the internet, it appears that phone number 84718-22154 is a Airtel number which is registered at New Delhi, and the current location of the said phone is at north. You just say N, capital N, 79.0 degree, longitude E 20.6 degree. Full stop. Next para, therefore, you say the geolocation, not location, geolocation is that. Next para, as it may, prior to issuance of notice, the court is inclined to request the London's additional senior government advocate to obtain instructions from the officer in charge of Thelamara police station as to whether any effort has been taken by the IO of the said IO is investigating the said FIR to have the geolocation of the holder of the said mobile tract. Geolocation of the mobile tract. And if so, the information we produced in a seal cover. Next para. In the meanwhile, the learned counsel for the petitioner shall produce a copy of complaint stated to have, complaint which has been referred in the FIR. Next para, list on. Next week would be okay, or you want some other day?
Some other day, madam. 4 August,
4th of August.
4th August.
It will be 2
Monday.
weeks.
Yes,
Okay, 4/8/2025. Next para. The pendency of this writ petition shall not be a bar for the investigation of the case to be carried out in an appropriate manner. Next, the learned additional senior government advocate shall send a downloaded copy of this order to the officer in charge of Thelamara Police Station. Next para, list on 4/8/2025.
Lordship.
Item 5.
This is your lordship, habeas corpus petition, your lordship. We have silenced the detention under National Security Act, lordship, of the petition. Detention under National Security Act, lordship. We have silenced the detention under National Security Act.
Oh, check, okay. Detention order under UAPA,
No, UAPL, National Security Act.
National Security Act. Okay,
National Security.
we'll have to issue notice then.
Lordship, notice will have to be.
Uh, By filing this, you say, heard Mr. S. Bhattakur, learned counsel for the petitioner. For Union of India, you are there, Mr. K. K. Parashar, learned CEC appearing for the respondent number 1, for the respondent number 1. And Mr. D. Nath, learned senior government advocate appearing for the respondent numbers 2 to 5.
2 to 5.
You'll be appearing for 3 also?
Yes, sir.
Okay, 2 to 5. Next paragraph. By filing this repetition under Article 226 of the Constitution of India, the petitioner has assailed the impugned detention order dated number capital NMM 17/2025/NSA/83 dated 14/5/2025, page 2. Issued by the District Magistrate, Nagaon, as well as corrigendum number capital NMM 17/2025/NSA/131 dated 12/6/2025, issued by the same authority.
Okay.
And also the order confirming the detention.
Also,
The order confirming the detention. That is at
as,
page 116.
comma, as well as the order, where is there?
Page 116.
One, one,
6.
6. This did not come to our notice because in the initial narration at the end of the matter of, you have not given that.
Lordship, cost title probably.
The hospital is not there. Okay. As well as order number capital PLA dash 42 oblique 2025 oblique 156 dated 3/7/2025 passed by the additional chief secretary to the government of Assam, Home and Political Department, thereby confirming the detention order on the basis of report of the advisory board. Next for the issue notice returnable on this is detention order. We are giving it on 13th of August.
Lordship.
It's very close to Independence Day, but we
Lordship.
can't avoid
We'll-
that.
We'll try. Lordship will try.
13/8/2025.
Madam.
Next, Karan. Extra copies of the petition be served on the Learned Senior Government Advocate, Learned CGC and Senior Government Advocate in course of the day, along with a soft copy thereof.
Lordship.
Next, Karan, response will be filed at least one day prior to the next date of listing,
Madam.
list on. When they give 13/8/2025.
13th.
Item 6.
Full say your lordship, 15 days for disclosure, your lordship.
Quickly,
That's
can't
difficult,
happen.
your lordship. Very difficult. Deeply obliged.
Yes.
May appeal versus. Expertly order me. Notice is stand
Which
by
page is
another-
that opinion? Which
Page 20 million,
20.
yes. That could be an originally just 22 million. Handwritten.
Okay. Heard Mr. A.M. Hamid, land counsel for the petitioner. The respondents are there. Next paragraph by filing this writ petition under Article 226 of the Constitution of India. The petitioner has assailed the ex parte opinion dated page 20. Take it from 22.
Yes. Happen. One thing, yeah, but.
Ex parte opinion dated 24/4/2017 passed by the passed by so-and-so in so-and-so. FT case number so-and-so, or they were holding the petitioner to be a foreigner post 25/3/1971 street. Next, the case projected in this petition is that the petitioner is a resident of UPOR, Upor Kahunda, Kahunda. But the notice of appearance was shown to have been duly served at village Nam NAM, Kahunda, Kahunda. Next, be there as it may. Issue notice returnable on. Give a date after 4 weeks. So and so. So, requisite extra copies of the petition will be served in 2 days. Call for the relevant record from the concerned tribunal by usual process as well as by registered post, email to the following email address of the concerned tribunal. Next, the prayer for bill shall be considered on receipt of records. Next, in the meanwhile, if the petitioner Mofidul Islam is apprehended, he shall not be deported out of the country without order of the court. Petitioner shall bring the this order to the notice of the Superintendent of Police border, Nagaon. Next, list on so and so.
And petitioner outside me.
We are not giving bail at this moment, but you will not be deported.
27 August. Item 7.
Imprint order is page 26.
No?
26.
Will not even issue notice on this.
Milord, in this case, Milord, one Aved Ali Farazi, he has taken time, Milord. He has to get adjournment, Milord. Whereas, Milord, he is not neither a family member, not known to that person, Milord.
Pardon me?
One Aved Ali Farazi, Milord, kindly see the adjournment petition, Milord. Page 21, Milord.
No, that is worse because if you've been served notice and that means you'd never appeared, let us assume that you are right.
No, Milord. She has never received any notice, Milord, at that point of time, Milord. And that is category stated in evidence of the husband, Milord. Kindly see page 28. Kindly see page 28, Milord. Before that tribunal.
Case. But come to page 31, even if we assume you are right, page 31, again, you ask for a setting aside of that order.
Yes, Milord.
That order is of 7/11/19.
Yes. 7/11/19, Milord. What happened, Milord? A tribunal, as per the order passed by the tribunal number 1, Milord. And that tribunal is, Milord, under the jurisdiction of Juria, Milord. A petitioner is falls under the Juria PS, Milord, and subsequently established tribunal 4th, Milord. And petitioner, Milord, submitted application before the tribunal number 4th, Milord. That application was returned, Milord.
Okay, then
Page 35, Milord.
35, you file another application.
Yes, another application, but the same is returned back, Milord, after 12 or 15 days, Milord. A petitioner initially filed, Milord, expert order before the 4th, Milord. The date was rejected, Milord. Without lack of jurisdiction, Milord. And a granted liberty, Milord, page 34. Directed to file petition with her liberty before the Foreigners Tribunal 1, page 34.
No, we'll take it up day after tomorrow. Will you address us on maintainability?
Yes.
You're not inclined. Give a copy to Mr. Sharma.
Yeah.
We'll heard your maintainability first.
Okay, I say two.
All sides are represented. Is the matter? No, just say, the ex parte opinion against the petitioner was passed on 8/5/2013. Most of the petitioner preferred a miss case, being miss case number 2 of 2018, to assail the ex parte opinion, which was dismissed with liberty to the petitioner to file a petition before the Foreigners Tribunal number 1, Nagaon. Dismissed by the London member, Foreigners Tribunal 4th, Nagaon, Juria, with liberty to the petitioner to file a petition before the Foreigners Tribunal number 1, Nagaon. Most of it is posited that the petitioner had filed a fresh petition before the London member, Foreigners Tribunal number 1 on 20/2/2020. And what had happened?
Returned back, my lord.
First of how the same was returned back to the petitioner. Next, in view of the inordinate delay in making challenge before this court, the learned counsel for the petitioner shall address the court on issue of maintainability. List on next Wednesday, 23/7/2025. Oh, just wait, we'll fix it on 25th. My court master says there are a lot of matters on 23rd, 25th. Item 8.
My lord, this case was, my lord, earlier, my lord,
Opinions at which
which
page?
is in ex parte.
Which page is the opinion?
Page number 45. That was earlier, my lord, this one.
No, the present opinion which you're challenging, where is that?
Present, my lord, page number 76, my lord, in the order of a revision petition, my lord. Page number 76. Earlier, an ex parte order was passed, my lord, and this honorable court had demanded the matter.
Yes, you'll address us on the maintainability first. 2020 order you are challenging now.
12, 20, my lord.
Yes, Mr. Kadir, please address us on maintainability.
My lord, I have mentioned in paragraph, para number 9 of page number 11, my lord, that the petitioner was not intimated, my lord, about the dismissal of his written review petition, my lord.
Paragraph 19.
Paragraph 9, my lord, of my
9.
9, my lord. That this dismissal was not within the knowledge of the petitioner. Only recently when he was, my lord, taken into custody by the local police. Then he inquired about the case and came to know, my lord. Paragraph 9 and 10, my lord. He resides in a remote village, my lord, of about 35 kilometers away from the.
Whatever it is, but your statement made it does not inspire confidence.
Yes, sir. 9 and 10, my lord, that is the only reason, my lord, regarding the not approaching this honorable court earlier, my lord. This is the only reason, my lord. The other hand, my lord, he has a sufficient documents, my lord. He has a sufficient documents, my lord.
The statement is one which we are not inclined to accept and issue notice. But this too vague. If we start entertaining a repetition on these vague grounds, it will be very difficult to then take a different view. You say that you thought that the petition was allowed. You thought that the petition was allowed. Even then you should go there and ask for a copy.
Yes, but that is the reason, my lord. He did not contact, my lord. That is the, my lord.
Then
That is the,
it's a willful default.
yes, my lord, he did not contact, my lord. The village person,
It's
my
a
lord,
willful default.
of a, he resides.
If the lawyer does not give you did not file an FIR, you did not make complaint against the lawyer, no bar council proceedings.
That is the, my lord, actual ground, my lord. Whatever he stated,
But
my
this
lord.
is not a ground to issue notice. It may be a good ground for you, but not a good ground for the court to issue notice, even notice, you have to dismiss it in limine.
My lord, otherwise, he has all the documents of the linkage with his, my lord.
No,
for
documents
that-
is second thing.
for
There
that
was an
court.
adjudication, you were given an opportunity,
My lord, his constitutional right, my lord.
2020,
My lord, citizenship right, my lord, will be, my lord, curtailed, my lord, if, my lord.
pardon me,
On any ground, my lord, his citizenship right will be, my lord.
but we can't help it.
curtailed, my lord.
If there's no explanation at all, you are aware that there's a proceeding against you, and then you think that it is allowed.
My lord, for this, my lord, on any ground, my lord, this honorable court may deem fit, my lord. On otherwise, my lord, he has the sufficient documents, and I have annexed, my lord, from his, the age, from the documents of a great
No,
grandfather.
we are
my
not
lord.
the original authority to appreciate a document.
Yes, my lord, since this matter is not disposed of on merit, my lord. At least a last chance, my lord, on any ground, my lord. He is regularly attending the local police station, my lord. On daily basis, my lord, he is attending, my lord.
No. We are not there to impose those conditions. If your explanation is not there, we can't issue a notice.
My lord, on any ground, my lord, since he has the documents, my lord, I have annexed the documents, my lord, the linkage also, my lord, with his father.
No,
my lord.
we are not even commenting on anything.
Yes, my lord.
There was 970 days delay.
That is the.
For that, you went to the tribunal, and that contravention application were dismissed in 2020. After 2020, how many days now?
Is well about
5 years.
about 5.
5 years is the thumb rule 350 into 1700, 1800 days. You can't issue notice like that. For 970 days day delay, you are now making a 1800 day delay.
My lord, on any ground, my lord, since the citizenship right is, my lord, is
No, no.
question, my lord.
Once somebody sleeps over the right,
Otherwise, he has, my lord, the documents, all the documents I have annexed, my lord, regarding the connection with his father, my lord.
no, we are not examining the original documents. Sorry, we're dismissing it.
My lord, this may be, my lord.
No, 18.6.
My lord, page number 27 and 25 may be perused, my lord, for a moment, my lord, regarding his connection with the, my lord, before 71, my lord, documents with his father and grandfather, my lord. Admittedly,
In
my
the
lord,
writ petition, we will not be able to appreciate any document.
yes, my lord, admittedly, my lord, he has some, my lord,
No.
default, my lord, on his part to the contacting the council, my lord. And my lord, this honorable court is a court of equity, my lord, regarding to safeguard his citizenship right, my lord.
No, equity doesn't mean that for 5 years you think that the petition is allowed. That cannot be encouraged.
Yes, that was, my lord, assured to by the lawyer, my lord.
No,
And definitely,
yeah,
my
sorry,
lord,
whatever you write, you
prima
have.
facie- prima facie, my lord, there is some default, my lord, on the petitioner's part, my lord, but that may be, my lord, on some stringent condition, my lord, that may be, my lord, considering the citizenship right, my lord.
You already, you see, you had a 970 days delay. After 900, you have, how would you say the correct word in English would be, earlier you were novice, then you graduated. Earlier you were novice, 970 days delay. Then you graduated. Now 1800 delay.
During this period, my lord, the COVID was, my lord, some time.
What would
also
be a good
the
reason?
Period
not-
was also
We are not
there, my lord.
inclined.
That may be, my lord,
We are not inclined.
my lord, consider.
But Mr. M.J. Kadir, learned counsel for the petitioner. All the respondents are there. Next further. By filing this writ petition under Article 226 of the Constitution, first of all, you say this no, it's okay. Article 226, read with Article 227 of the Constitution of India. The petitioner has said the opinion dated 7/12/2020 passed by the learned member from Foreigners Tribunal, Hailakandi. Page 45. By which the petitioner, namely so-and-so, was declared to be a foreigner post 25 to 1971 stream. Next para. The petitioner had assailed the said order, said opinion by filing WPC 3843 of 2017, and the division bench of this court by order dated 20/12/2017 closed the writ petition by directing the petitioner to exhaust his remedy under Order 3 capital A within bracket 1 bracket close of the foreigners within bracket tribunals bracket close order comma 1964, and in view of the alternative remedy available, comma, the writ petition was closed. Next paragraph. According to the petitioner, had filed a missed case before the said learned tribunal, bearing petition number 8 dated 18/1/2018, under order 3 capital A within bracket 1 bracket close of the foreigners within bracket tribunals bracket close order comma 1964. Power, the said learned tribunal by order dated 5/3/2018 having not found sufficient cause for not appearing before the learned tribunal in connection with FT case number 14 of 2016, rejected the prayer and the missed case was disposed of. Post of against the order dated 5/3/2018, the petitioner filed an application under order 3 capital C within bracket 2 of the foreigners bracket was tribunals bracket was order 1964 read with section 114 of the CPC for review of the order dated 5/3/2018 passed by the learned foreigners tribunal, Hailakandi in FT case number 14 of 2016. They said review petition, which was registered as review petition number 1 of 2020. Was dismissed by an order dated 7/12/2020, holding that the review petition was devoid of any merit. Accordingly, the said impugn opinion dated 29/3/2017 is, no, not 20, mistake. 29/3/2017 is being assailed by the petitioner. Next paragraph. From the materials available on record, it appears that in order to file the, there was a delay of nine hundred. What is it, 970?
70 was 970.
970 days in preferring the review petition. And that from 7/12/2020 till this writ petition was filed on 24/6/2025, there has been a further delay. There's been another, there's been a delay of so and so days. Let's find it out, huh? Next paragraph. Accordingly, the court has heard the land counsel for the petitioner on the maintenance of the writ petition as the order passed in the review petition number 1 of 2020 dated 7/12/2020 has been challenged after so and so days. Next paragraph, the learned counsel for the petitioner has referred to the statements made in paragraph 8 to 10 of this writ petition, project that though the petitioner has sufficient documents to establish that he is a Indian citizen, combat the petitioner was not informed by his learned counsel about the dismissal of the review petition by order dated 7/12/2020. Stop. The learned counsel for the petitioner has submitted that the petitioner is a poor village person and resides in a remote village forest, and that the petitioner was dependent on the advice of his learned counsel that the petition would be allowed. And that only after the petitioner was apprehended by the police on
27/5/25.
27/5/2025, the petitioner came to learn that the review petition was dismissed. Next paragraph. It appears from the statement made in paragraph 10 of the writ petition that the petitioner was released on 30/5/2025, on condition to appear before the police station daily. So I had Mr. G. Sharma, the study counsel for the FT matters, who opposed the writ petition. Next para. In this case, the petitioner is aware of an ex parte opinion dated 29/3/2017, declaring him to be a foreigner. Full stop. The said order was assailed before this court. And thereafter, pursuant to orders of the court, the petitioner had appeared before the jurisdictional tribunal Mr. Hawa, the said review petition number 1 of 2020 was dismissed by order dated 7/12/2020. Stop. The explanation tendered by the petitioner in paragraph 9 of the writ petition is that the dismissal of review petition was not informed to the petitioner by the council, and the petitioner is a poor village person of remote forest village, and he thought that the petition was allowed as per the assurance of his counsel. Full stop. In the considered opinion of the court, even if the petitioner thought that his review petition was allowed, then also there was a requirement of the petitioner to appear before the concerned tribunal and to file his written statement to contest the proceedings. Full stop. Neither the petitioner took steps to become aware of the orders that was passed in review petition number 1 of 2020, and resultantly he did not approach this. He did not assail the said order within a reasonable time thereafter. Full stop. Next part, the only said explanation that the petitioner is residing at a remote village forest and is a poor person, and that he thought that the petition was allowed, does not, in the opinion of the court, be considered as a good explanation of the delay so as to issue notice in this writ petition. Next part, the delay and latches of so and so days is found to be without any good explanation, good cogent or reliable explanation. Next part, although there is no limitation prescribed to entertain a writ petition, but the delay and latches in this case in approaching the court to challenge the impugn order passed in this case number 1 of 2020 is so and so days, and the resultant delay in assailing the opinion dated 29/3/2017 as on 24/6/2025, the date on which this writ petition was filed would be so and so days. Next, in view of the inadequate explanation of the delay and latches, the court is disinclined to issue notice. So accordingly, the writ petition is found to be not maintainable on the ground of delay and latches. So accordingly, this writ petition is dismissed at the motion stage without issuance of notice on the respondent. Next paragraph. The learned standing counsel for the empty matters shall send a downloaded copy of this order to the concerned foreigners tribunal at Hailakandi to bring the order to the notice of the said learned tribunal.
Item 9.
Maybe law. Opinion, my lord, page 57.
Which page?
57.
57.
That's a profile.
Okay. Heard Mr. H. Halil and counsel for the petitioner. Opinion is at page 57. All the respondents are present. Opinion dated 31/5/2025. Passed by so and so. In case number so and so, IMDD case number so and so, thereby declaring the petitioner to be a foreigner post 25/3/1971 stream. Notice returnable in 4 weeks, extra copies within 2 days. Call for the records. Prayer for bail is opposed by the learned standing counsel for the FT matters. Considering the projection made in the writ petition. 10 days time to take bail of rupees 5,000 to the satisfaction of Superintendent of Police Border,
Superintendent Golpara.
Gwalpara. Okay, list after 4 weeks on receipt of records.
Hello.
Item 10.
Order you think starts from page 41.
41.
Page 41. So he submitted a written statement here, okay. That was elaborately written statement was elaborately discussed in this.
8/24. Okay.
Yes,
Heard Mr. R.P. Hazarika and counsel for the petitioner. Mr. Hazarika, you have started not to take good care of your clerks.
so the WS is missing your option.
I don't know. This is how they have started writing your name. Take good care.
RPN. Not R.
I don't know, Sam. If you don't take good care, this will happen.
Yes, sir. This is,
I have a bad habit of presuming things.
full name is necessary, your Honor.
Huh?
Full name is necessary. Full sign, full name in legal proceedings, your Honor.
R.P. Hazarika, counsel for the petitioner. All the respondents, the same order. Opinion is at page.
That's page 41.
It starts from 41.
41 to 47.
41, opinion dated 27/8/2024. Passed by so and so in case number so and so, FT case number so and so. They were declaring the petitioner to be a foreigner post 25/1971 stream. Same order, bail of rupees 5,000 to the satisfaction of
Udalguri.
Udalguri.
Nomenclature of respondent number 5 may be corrected.
Udalguri. You are right. Come to page 42. Who will have the records?
Udalguri.
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 It will be with Udalguri, but here it says the Dorang Mongolai.
It was
Forty-two
separated.
says SP Dorang Mangoldoi.
Earlier, the
Earlier lordship, it was perhaps in Mongoldoy lordship, Dorong,
Okay,
subsequently.
SP Bodo Udalguri.
and lordship, respondent number five may be corrected, lordship.
Respond by 5. There's a mistake.
Only this,
Here they have corrected it, district.
yes.
So Daniel,
Fellow-
just check this
development
WPC 3971 of 25. Who is respondent of 5?
Deputy Commissioner Udalguri, district, it should be district.
No,
commissioner.
here they have corrected district, but what is there in the central registry, we are checking it up.
Yes, true. Lord,
No, just wait. WPC 3971 of 25. Respondent number 5 is district commissioner.
Yes.
Okay, corrected. Make correction in his copy also.
Totally correct.
Item 11.
Wait, this lordship. That's fine. Fine.
Nineteen or. Notice double. Notice double.
Wait, this is lordship. Ex parte order has been passed against the petitioner lordship.
Page?
Page number 18.
Your name is the serial number? Number 1, I think.
Rohima Khatuni's lordship.
Need to same order. Same order. No. No, but from the statement when is the writ petition, It appears that you have changed the address after the reference was made,
Yes, Lordship.
and you did not inform the authorities. And in paragraph 3 of the opinion at page 18, it is mentioned that it was pasted at a conspicuous place at the last residence. So if it is a good service under 35F,
Yes.
you have to tell us why we should issue notice. We'll take it up on Friday if you're not prepared. Okay. All both sides are represented. It appears from the statement between paragraph 3 of the writ petition read with paragraph 3 of the common order dated 27/3/2019. From it privacy appears that the petitioner changed address after the reference was made and did not inform the authorities. And that the notice was served in a manner which is permissible under section, under order 3 within bracket 5 within bracket small f of the foreigners within bracket tribunals bracket close order on 1964. So according to the question of maintainability, the land council for the petitioner seeks to time some time to address the court. Next list on Friday, 25/7/2025. Your name?
Bidas.
Ms. P. Das, the advocate for the petition.
Item 12.
That means Lordship. Lordship will be now in my lord, page 62, my lord. 62, my lord. Lordship.
You have to address us on maintainability.
I have stated in paragraph number 23, my lord, page 17, my lord. The petitioner belongs to very poor family, my lord. And during the COVID period, my lord,
Just one paragraph
23, my lord,
23.
page 17, my lord.
But this is not a good explanation. It's no explanation at all. It's very vague.
The petitioner is very poor, my lord. That is why I know.
This is not a good ground. For this, we can't condone 6 years.
Item 28, 29 will be.
Sorry, Mr. Baba, we're discussing this writ petition.
Lordship, I'll argue on maintainability on the next time, my lord.
Okay, next Monday then.
Lordship.
Mr. A. Mubarak, land counsel for the petitioners. 6, some time to address the court on the maintainability of the writ petition on the ground of delay and laches, unexplained delay and laches to assail the opinion dated 28/6/2019. All the respondents are present. List on 28/7/2025.
Item 13.
His lordship at 52.
52. This is again 2019.
His lordship.
Addresses on the issue of maintainability.
There are
Why we should
17 pages.
entertain the petition after
Lordship,
6 years.
Just 12 lordship. There are 17.
Para 10,
There are 17
17.
lordship. Just 12. Same ground lordship.
There's no explanation at all.
Yes, lordship.
Financial hardship is. This can't be excused. The state government is spending a lot for providing free legal aid. Sorry, you are Mr.
SI Talukdar.
S.I. Talukdar. We are dismissing the repetition.
Maybe apples my senior Mr. Shikda lordship.
Pardon me?
Lordship, this information lordship regarding the mentality lordship, he addressed the court lordship.
We are not getting it. Please repeat again. Oh, your senior will submit. Okay. Okay, then Monday,
Yes, lordship.
the same order. His name is Mr. S.I. Talukdar. And he's challenging the opinion dated 27/9/2019. Okay.
I love that.
Item 14.
Yeah, please, lordship. Lordship, this matter also. Question will raise my on maintainability.
Which page is the opinion?
And lordship 48, my lord.
Page
48, my lord.
48.
15/11/2018, my lord.
No,
I played my lord 1 is time, my lord. In this as well.
Okay. Same order here, Mr. A. Mubarak. Opinion is dated 15/11/2018.
18.
Okay.
What?
Supplementary item 28 with 29 upgraded for orders.
Well, here on last occasion, Lordship has directed on 18/6.
Yes.
I have two instructions. Now, tomorrow or day after tomorrow, the joint meeting is going to be held with the finance department.
Pardon me?
The joint meeting as directed by the Lordship, it is going to be held tomorrow or day after tomorrow. I have been informed that they have on 16/7/25 written a letter to the finance for a meeting, my lord. Tomorrow or day after tomorrow, it is going to be held. And secondly, my lord, they have said that already a financial sanction proposal amounting to rupees 18 crore has been received from the Assam State Legal Services Authority on 17/7/2025, and the same is under process. And in the meeting, my lord, the Standing Finance Committee, they are going to place it, and in the meeting, my lord, they are going to discuss that, my lord. But,
Mr. Nath, you see, what we are trying to understand from the state is
logic.
that let us say that the courts will give you a financial outlay of the disbursements to be made by the district legal service or the several district legal services authority
My lord.
after compilation of data of a particular date. Let us say that if the state legal services authority is writing to you today, that means it will contain the facts and figures, maybe say of 30 of June,
True.
30th June.
True.
Now, in between 30th June, so let us say from 1st June till today is 21st, if some payment is required to be made, how does the government foresee to plan out? Because the idea is that we must have a clarity so that you see the district legal services authority can disburse the amount, or you authorize them to disburse in part. Because you must make a policy. You see, the district legal services authority is created by a statute.
True, my lord.
And the victim compensation and all, they are all by statute. It is not the court which is doing it by itself.
My lord.
And in none of the cases we have appealed against the quantum of compensation granted, because they are not normally within the scope and ambit of the various provisions of law.
Logic.
Now, if we have to pay compensation, we means the district judiciary.
Logic.
If they have to make compensation, how does the government propose that they would bring it to a logical conclusion?
But specifically as
No,
you-
not from you. We want this answer from
Logic.
the authorities when they hold the meeting.
True. But what I would like to submit, my lord, in respect of the 2 lakhs rupees interim compensation as Lordship has directed, well, I have put a specific query to the secretary concerned that the court wants that this interim amount should be released to the petitioner shortly, immediately. The answer which I have received is, that I have got, is that there is no such separate account for release of the amount. Ultimately, that has to be routed through as per so far the mechanism as on today is concerned, my lord, it has to be routed through the DLSA, and that is why, my lord, I have requested them to, when they are going to hold the meeting with the finance, they should keep it in agenda that if this things comes up, what mechanism they propose, my lord, or how they will tackle it. They will let, at least that is what, my lord, I have indicated, that they should come up with something.
There's another way of looking at it.
My lord.
Our perspective of looking at it.
Logic.
You see, somebody has died within in police custody.
Logic.
So prima facie, when we are giving a direction to make payment, we are prima facie holding that the Article 21 has been violated.
Yes.
Now, apart from that, if even a payment of compensation is delayed, what should be, according to you, what should be our perspective of looking at it?
But I'm fully agreeable with the concern of the honorable court, my lord. But
We take it up on next Monday, but bring some solution.
lordship, let
We
the
want
meeting-
a clarity
Lordship.
on the government policy and how to disburse this.
Lordship.
And this is not a problem with only one district.
Correct.
It's a problem which comes to us through all the districts.
Lordship. The mechanism which I got to know, my lord, that it's from the budgeted amount only these are being paid. But the cases are coming up. There are various situations, my lord.
No,
That has to be.
But that's why we want a clarity. You see, now, if today the court passes an order, if again it goes through the usual process of making a budgetary demand and then making a supplementary budgetary demand, that would mean that the payment is not coming to these victims before say, April 15th of the next year. And please also try to understand, or you ask them to understand the perspective of the court. You see, we are not trained as judicial officers, neither I nor my judicial officers in the state. They are trained to act in accordance with the budgetary
Allocations.
not allocation, the appropriate moment to make a budgetary demand.
Well,
We are not trained in that. Although for last few years, we get training now and then about how to deal with the budgetary demands. But every state has a different way of putting across the demands. So even the resource persons who come to tell us, they will say our resource person comes from Delhi, from the finance minister from the Union of India. They come, they have their own perspective. They don't know about how the process takes place in the state of Assam. And therefore, if you tell me how to make a budget for the functioning of this court, let us say, how do you make a budget? If you ask me, I'll not be knowing it. Let us say that today a new act has come. I'll tell you, don't forget about others. We tell you about the foreigners tribunals which we are dealing with right now. Are you aware that in foreigners tribunals no books have been provided? Law books have not been provided. The new BNSS, the new what do you call BNS and the Evidence Act, new Bharatiya Sakshi Adhiniyam, they have not been provided to any of the tribunals. Now, can we say that because the officers do not know how to make budgetary allocations, they will not have books? Your law department would have procured it and give it to them. They know that X number of tribunals are there. And are you aware that this foreigners tribunal, none of these foreigners tribunals have received any law books like GLR, GLT? Therefore, orders which we are passing, the tribunals don't know how to how to gather knowledge and then to adjudicate. So this is with the law we are dealing with, small. And nobody will write to you, to the state government, to give budget for books.
These unforeseen things, some can be seen, but
But
there are some unforeseen.
there must be some policy.
Lot.
There must be some policy, because that's why we find that, you see, why we did that query is that we find that there are repetitive mistakes made by the tribunals of the similar orders which we have already dictated. Let us say in order A, we say that you don't do it like this. Second order comes with the same mistake. Therefore, an inquiry why this has happened. Then the feedback we got when we asked the registry to find out, the response we got is that they don't have books.
Books are not there. Well, in the infrastructure bench, I have some knowledge.
No, it's not a question of infrastructure bench. We don't have.
Some steps are being taken now.
No, not that.
By the GL.
You see, in the infrastructure bench, if these things are not raised, how will the infrastructure bench take care of it? And books is not infrastructure.
Books have come. The question of books have come.
But books is not infrastructure. You can't say that the pencil, which is a requirement of the court, will be an infrastructure.
In fact, so many things have come there.
No, maybe, but we are compelled to do it. Maybe perhaps the court was compelled to do it because this requirement of pencil was there and didn't come.
From time to time, the applications are being coming up from the members. And in that way, matters have been taken up. So I have some knowledge that some steps have been taken to provide.
I'm not seeking an explanation from senior government advocate. We are asking for an explanation of the state. We don't want to embarrass you by putting questions, so that we are not asking immediate reply.
True.
But when you are holding a meeting,
True.
for this judicial side, I think you'll have to take a proactive step.
Logic.
We are not even aware. You see, last time parliamentary committee had come. We had an interaction with the parliamentary committee which came 2 years before. We had made a request to the parliamentary committee that whenever the funds are earmarked for the judiciary, make it in a non-lapsable funds. So after 2 years now, the government has agreed in principle that this infrastructure expenses will be given to in a global head account. It took 2 years for the government to accept that. This compensation business must, you'll have to take care of it. The state, not you, means, you
True,
means
true, Malad.
state for us.
Yes. The departments are sitting Malad, shortly, so take up on Monday, I'll come up with the what decision they take. Malad.
Okay. Your name?
Miss D. Bora. Miss D. Bora, Lordship.
C. Bora.
D. Bora.
D. Bora. And Ms. D. Bora, and counsel for the petitioner. Next, Mr. D. Nath, learned senior government advocate, has submitted that he has received instructions that very shortly a joint meeting between the Home Department and the Finance Ministry
Finance.
of the government of Assam would be having a joint meeting. He expects that the same would be done within 2 or 3 days.
Malad.
Next para. Accordingly, list the matter on Monday, it's 28.
Lordship.
So as to enable the Granite Senior Government Advocate to obtain instructions and to address the court.
Malad.
Mr. Mahmood, Monday, they are holding a
Right.
meeting in 1
Yeah.
1 or 2 days.
Lordship. I'm on that purpose.
We'll have to rise.
Pilot, item 27, can it be taken up on Friday?
This week, there will be some disruptions.
Malad,
So,
next fixed on 29 in the trial court, my lord. There is direct trial court in 29 date fixed. Your lordship directed to make an inquiry to the, my lord, SP, whether the proceedee and the petitioner are same person or not. That inquiry report also is required possibly.
Mr. Sharma, have you got that?
I still inquired.
Item number
27.
27.
7.
SP Parivali. SP Parivali.
I will check, Lordship.
Hmm?
I will check, Lordship. I will check. At present, I don't have the instruction, Lordship.
Okay. The issue of identity.
My lord,
No, Mr. Hawks says that we have passed an order on the last occasion.
26 5.
The report to subordinate.
Lordship. I will check, Lordship.
Okay. But due to positive time, matter could not be taken up today. List on Friday. We'll be rising for the single bench.
Lordship.
Mr. Nath, we'll require you for a moment. We have something to tell you.
Lordship. Lordship. Order.
Single bench item 1 for orders.
Yes.
May please, Your Lordship. Today also my senior is absent, my lordship.
He has to be absent because he's a most engaged senior counsel.
Yes, my
Then,
lordship.
but we can't fix our roster according to his presence. You'll have to do it, whether you like it or not.
Lordship. We start with me to pass over the matter for the day only, my lordship.
No, but you see, we are in a division bench. We have to break it and then sit in the single bench. You can't do it every time. It has been adjourned 3 or 4 occasions. You can't afford to do that. We have given you few adjournments, but it can't happen every day. So you'll have to begin. Ms. Begum, you can't help it.
We have filed our additional affidavit, my lord.
Written,
We have filed our additional affidavit, my lord.
we didn't get it. Please repeat again.
We have been filed our additional affidavit, my lord.
You filed your additional affidavit. Okay.
Already the petitioner also filed a criminal petition. The said petition was disposed of. The criminal proceeding against the petitioner was set aside, my lordship.
Please repeat again. I'm not, you're not audible. Please repeat again. Please speak loudly.
The petitioner has filed criminal petition against the order of framing charge, which was pending in the before the session judge in Gulaghar, which is set aside by this court, my lordship.
No, but that is, that has no immediate nexus with the criminal proceedings. And therefore we had quashed it.
Criminal proceedings.
Because when this matter was taken up, this criminal petition, then the record says that Mr. M.K. Das appearing for respondent, but two says that he has no interest in prosecuting. And therefore we had quashed it.
On their affidavit, on the basis of the affidavit filed by Respondent.
We won't make any comment, but you see what has happened, whether the victim wishes to prosecute or not. But to exercise power of review, you have to tell us why we should do it. Because if the victim does not want to prosecute it, you're there also. It can always be closed. Because by the order, referring to the past rules, we have said that the ICC would make an endeavor to conclude the proceeding within a reasonable time.
Only aspect, my lord, now they have to satisfy the honorable court as to whether there are new facts and circumstances for exercising the power of review, my lord. So, one aspect, my lord, same facts and circumstances.
But that is something which ICC will have to do it. We can't usurp the role of ICC.
My lord. There are, my lord,
We can't say right now that the ICC may not find anything incriminating.
my lord.
It will amount to a question which under these rules, we can't do it.
I, my lord, appear for the private respondent number 5.
We
the
understand.
victim, my lord.
We have no objection to the closure.
Yes, my lord. In fact, my lord, I filed an application before the committee also. Under section 10, but that chapter goes, my lord, because now the situation has come to a different aspect altogether. Now, my lord, the only aspect is whether, my lord, the proceeding can be, my lord, that ICC proceeding can be quashed or not. My lord. That is the limited aspect.
We don't think so, and we should not. Because it gives an insecurity feeling to all staff who are female. One may not prosecute, but then the perpetrator of the crime would be emboldened. If one can be dissuaded, I have a personal the privacy view is that why should we start thinking what the ICC will find? And if the ICC does not take steps in accordance with law, they face the consequences. If a statement is unreliable, we have made that observation in paragraph 19 of the order. If a statement is unreliable, then the ICC will close it. Without. Oh, sorry, in the writ petition. In this review petition, they take a ground.
They are seeking well, de novo trial in the ICC before the ICC.
Let them proceed because if they're if they're the complaint doesn't want. Prevention of sexual harassment of women at workplace. The only issue in this review petition is whether the order to file written statement of defense and to further cross-examination is in consonance with the provision of 10(1) of the Act. That is the only question. Prevention of sexual harassment of women at workplace. You have a copy of that act? You have a copy of the act?
My lord, I don't. Ase answer. Ase.
Your lordship, I don't have the act, but I do have a printout of the act.
Okay, we got it. Okay, I've examined and pass orders. Take into consideration section 10(1), which you're trying to raise 10(1) and 11(1).
My affidavit, my lord, I have submitted the communication that had taken place between me and the department. There, my lord, the stand of the committee is that because the case proceeded to section 11, so section 10 will not come now. My lord.
We've seen that.
That is, I have placed it.
That's why we have to examine the section 10(1) and then 11(1) together,
My lord.
in light of that.
My lord.
Okay. Mrs. R. Begum, and counsel for the review petitioner, had prayed for an adjournment, which was refused as the matter was adjourned on several occasions. Next one, heard Mrs. R. Begum, and counsel for the petitioner, comma, Mr. M. K. Das, and counsel for respondent number 5,
My lord.
and
D Khan for respond number 1, 2, and 3, your lordship.
okay, and Mr.
D Khan.
D. Khan,
Yes, your lordship.
land counsel for respondent number
1, 2, and 3.
1, 2, and 3, and will be appearing for 4. Your name?
BP Sharma.
And BP Sharma, and counsel for respondent number 4. Argument is concluded, your order reserved. Okay.
Your lordship, just one just clarification that even if they're seeking to quash or remove this ICC proceedings, there are 2 charges. One was for sexual misconduct and the other one was for the charge number 2 was regarding him leaking out the question paper. So that we may be allowed to pursue in the matter, your lordship.
Just a moment.
It's at page 79, your lordship, of the review petition.
Allegation of leaking question paper,
Yes, your lordship.
but that is not linked here.
Lordship?
We never stayed any other departmental proceedings.
No, your lordship. No, your lordship. I'm just putting forth a clarification so required.
No, but why is clarification required?
Because
We did not file any application for this for the clarification.
No, your lordship.
Because unnecessary things which we are, it's not a subject matter. You see, it's a writ petition filed by the petitioner,
Yes, your lordship.
and he assailed the complaint.
Hmm.
But then there will be no occasion for us to deal with any prayer made by the respondent.
Lordship. Understood.
And my lord, this is a case of sexual harassment at workplace. That is the subject matter of some other maybe.
Yes.
Speaking of the first one.
Yes, you are right.
Noted.
Okay. We'll keep in mind, but it may not come in the order.
Noted.
It's item 2.
May it please the Lordship. Lordship, in discuss, I am appearing on behalf of KK Datta, and he has some personally difficult today, madam.
Pardon me?
He has some personal difficulty today, madam. Actually, he is not well, madam.
Okay, on the ground that Mr. K.K. Datta and counsel for the petitioner is unwell. Miss
S. Sutya.
N. Sutia, and the government advocate, prays for adjournment. Prayer is allowed. List. After a week,
Madam.
on a date to be fixed by the office.
Obliged. And Sutya, S. Sutya.